In the spring of 1974, detectives in Fort Worth, Texas, sat across a table from a 31-year-old truck driver. They asked him about a firearm. He gave them an answer. He agreed to a polygraph examination, and the machine indicated he was telling the truth. Investigators crossed his name off their list and moved on. That truck driver walked out of the building a free man. It would take 46 years, 5 months, and 3 days before anyone in law enforcement said his name again in connection with this case. And when they finally did, it was not a witness who identified him. It was not a confession. It was not a fingerprint. It was a few billionths of a gram of genetic material, recovered from a piece of clothing that had been sitting in a paper evidence bag since the Nixon administration. This is the story of how one of the coldest cases in Texas history was solved using a forensic method that did not exist when the crime was committed, a method that has since rewritten the rulebook for unsolved cases across the United States. This is the case that investigators, prosecutors, and forensic scientists say became the first of its kind to be tested in front of an American jury. You're watching True Crime Files Decoded. If you value carefully researched, fact-based documentaries that focus on the investigation and the science rather than the sensation, take a moment right now to like this video, leave a comment, and hit that subscribe button. It genuinely helps this channel continue producing work like this. Now, let's begin. To understand what forensic science accomplished in this case, you first have to understand how completely the trail had gone cold. And to understand that, you have to start with the young woman at the center of it. Carla Walker was born on the 31st of January, 1957, in Fort Worth, Texas. She was the daughter of Leighton Walker, a retired United States Air Force lieutenant colonel, and his wife, Doris. In the winter of 1974, Carla was 17 years old, a junior at Western Hills High School in the suburb of Benbrook. She was a cheerleader and a member of the tennis team. Standing just 4 feet 11 inches tall, she was remembered by classmates as friendly and outgoing, the kind of student who greeted nearly everyone she passed in the hallway. She was dating Rodney McCoy, the quarterback of the school football team, and the two of them had made plans to attend Texas Tech University together. On the evening of the 16th of February 1974, Carla and Rodney attended a Valentine's dance at their high school. Afterward, they drove around with friends, and in the early morning hours they stopped at a bowling alley on the west side of Fort Worth. What happened in that parking lot would remain an open wound for the community for nearly half a century. According to the record later presented in court, an assailant approached the couple's parked vehicle. Rodney McCoy was struck and rendered unconscious. During the struggle, an item fell from the assailant's firearm onto the pavement, a small metal magazine, the piece that holds the ammunition. When McCoy regained consciousness, Carla was gone. He drove to the Walker family home, and police were called. 3 days later, on the 20th of February 1974, 2 officers located Carla's remains in a culvert near Benbrook Lake, roughly 5 miles from the bowling alley. The medical examiner determined that she had been held for approximately 2 days before she died, and that she had been sexually assaulted. She was 17 years old. Her funeral drew more than 1,250 mourners, and her classmates raised money for a memorial that was installed in the front hallway of the school. That is where the facts of the crime end, and the facts of the investigation begin. And for a very long time, the investigation had almost nothing to work with. The Fort Worth Police Department, along with several partnering agencies, formed a task force. They ran a tip line around the clock. They followed hundreds of leads. But the physical evidence available to them in 1974 was extremely limited, and the technology of the era placed hard boundaries on what that evidence could reveal. Consider what investigators actually had. They had Carla's purse, recovered from the parking lot. They had the metal magazine that had fallen from the firearm. They had blood on Carla's clothing, which testing determined belonged to Rodney McCoy from the injuries he sustained. They had no usable fingerprints. They had no eyewitness who could describe a face. Rodney McCoy, who had been rendered unconscious almost immediately, underwent hypnosis in an effort to recover any additional detail, and he was able to recall only a hat. The single most promising physical lead was that dropped magazine. Investigators traced it to a specific model of 22 caliber Ruger firearm. The Federal Bureau of Alcohol, Tobacco, and Firearms produced a list of local individuals who had purchased that model of weapon. On that list, among roughly 24 names, was a truck driver named Glenn Samuel McCurley Jr. In early March of 1974, detectives interviewed McCurley. He told them that his Ruger had been stolen from his vehicle several weeks earlier while he was fishing, and that he had not reported the theft. He agreed to a polygraph examination. Based on the results of that examination and his explanation about the firearm, investigators eliminated him as a suspect. It was a decision that would haunt the surviving detectives for decades. One of the original investigators, Jim Minter, later described the limitations they worked under. Police departments of that era did not have computers. There were no cameras in the parking lot, no automated systems reading license plates, no database that could instantly cross-reference records across jurisdictions. Every lead had to be run down by hand, on foot, one at a time. And crucially, the biological evidence collected from the scene could not be individualized. The science that would one day connect that evidence to a single human being was still decades away from existing. There was also an early suspect who drew significant attention, a man who abducted another young woman in nearby Arlington in April of 1974, and who confessed to other crimes. Investigators examined that connection thoroughly and ultimately ruled him out. The task force eventually disbanded. Carla's father kept a metal box of leads and notes until his death in 1987. Her brother, Jim Walker, would carry the case forward for decades, refusing to let it be forgotten. And so the file went cold, not for months, not for years, for more than 4 decades. The path back to an active investigation began in January of 2018, when Jim Walker contacted the Fort Worth Police Department's cold case unit. The case was assigned to Detective Leah Wagner, who had joined the department in 2000 and had moved into cold case work in 2018, and to Reserve Detective Jeff Bennett. Together, they began to re-examine everything. The key question was whether any of the original biological evidence had survived, and whether it could now be tested using methods that had not existed in the 1970s. Carla's clothing, including her undergarments, had been preserved in paper bags in the Fort Worth Police Evidence Facility. An earlier attempt, reportedly around 2007, to develop a genetic profile from the degraded material had failed. What changed the trajectory of the case was a combination of forensic science and, unusually, a television program. In April of 2020, the case was featured on an Oxygen Network series focused on cold cases and DNA. The network paid for advanced forensic testing at the Serological Research Institute in California, a laboratory that specializes in the analysis of biological evidence. The initial testing there reportedly cost at least $18,000. At that laboratory, analysts made a critical discovery. On the strap of Carla's undergarment, there was a small stain, one so faint it was barely visible. Within that stain, analysts found intact biological material, and from it they developed a single-source male genetic profile. This was the profile of one individual, and one individual only. But a genetic profile, on its own, is only useful if you have something to compare it against. Investigators uploaded the profile to the National Criminal DNA Database, the system known as CODIS, which contains the profiles of previously convicted offenders. The search returned no match. Whoever this profile belonged to had never been entered into the criminal database. In the traditional model of DNA investigation, this would have been the end of the road. It was not the end of the road. Because a different kind of laboratory, using a fundamentally different approach, was about to enter the case. Here it is essential to explain the science clearly, because it is the reason this case was solved, and because it represents a genuine turning point in forensic investigation. Traditional criminal DNA testing, the kind that had existed since the late 1980s, examines a relatively small number of genetic markers, somewhere between 13 and 20 locations in the genome. That method is excellent for confirming whether a known sample matches a known person, and it is the backbone of the CODIS database. But it has 2 significant limitations. First, It requires a relatively good quality, sufficient quantity sample. Second, and more importantly, it can only identify a person whose profile is already in the database. If the individual has never been entered, the profile has nothing to match against. The newer method is called forensic genetic genealogy, and it works on an entirely different principle. Instead of examining a dozen or so markers, it reads hundreds of thousands of markers across the entire genome, specific points of variation known as single nucleotide polymorphisms. This produces a far richer profile, one compatible not with the criminal database, but with the public genealogy databases that millions of ordinary people use to research their family histories. The insight at the heart of this method is simple but profound. Your DNA does not only identify you, it also carries the genetic echoes of your entire extended family, your cousins, your second cousins, your relatives many times removed. This means that even if an individual has never taken a DNA test, some of their relatives almost certainly have. And if you can find those relatives in a genealogy database, you can build family trees, trace the connections, and narrow the field until you arrive at one specific person. The laboratory that performed this work in the Carla Walker case was Othram, based in the Woodlands, Texas. The company had been founded in 2018 by David Middleman and Kristen Middleman, and it specialized in exactly the kind of evidence that had defeated every previous effort: degraded, contaminated, and extremely limited samples. Othram's proprietary process, which it calls forensic-grade genome sequencing, uses advanced sequencing technology to build a usable profile from material that older methods could not handle. There was a serious problem, however. The earlier testing had already consumed most of the tiny sample. Detective Bennett later recalled that only a very small amount of genetic material remained, on the order of a few billionths of a gram. Detectives faced a difficult decision. If they sent the last of the sample to Othram and the process failed, there would be nothing left. They took the risk and shipped it. Othram's scientists sequenced the sample, and their genealogy team went to work building family trees. According to testimony later given in court, the crime scene profile was found to match individuals who appeared to be cousins within a particular family, a family that carried the surname McCurley, with roots traced through Denton County, Texas. On the morning of the 4th of July, 2020, David Middleman placed a telephone call to Detective Bennett. He told him that the DNA had been connected to a specific family tree and that the surname was McCurley. Bennett later described that moment as deeply emotional because he felt he was finally hearing something that detectives had been waiting more than 4 decades to hear. It is important to be precise about what the genealogy provided because this precision matters both scientifically and legally. The genetic genealogy did not, by itself, prove who committed the crime. It produced an investigative lead, a surname, a family, a direction. As Detective Bennett himself put it, the information could be used as an investigative tool, but detectives then had to go back and prove it through independent means. Investigators connected the surname to Glenn Samuel McCurley, Jr., and here the case delivered a detail that stopped the detectives cold. McCurley was already on their reinvestigation suspect list. He was number 22. He was the same truck driver who had been interviewed and cleared in 1974 over the .22 caliber Ruger. The man the genealogy had pointed to was a man the original task force had spoken with and released 46 years earlier. Now investigators had to establish direct proof. A family tree could point them toward a suspect, but a conviction would require McCurley's own genetic material compared directly against the crime scene profile. To obtain a first sample without alerting him, detectives conducted what is known as a trash pull. In July of 2020, they collected the garbage McCurley had set out at the curb for disposal. Among the discarded items was a drinking straw. The laboratory compared the genetic material on that straw against the single-source profile developed from the evidence. It matched. That match provided the probable cause detectives needed, but they took an additional step to strengthen the case. Detectives Wagner and Bennett visited McCurley at his home, spoke with him, and obtained a voluntary cheek swab, a sample collected directly from the inside of his mouth with his consent. Laboratory analysis confirmed that this sample too matched the crime scene profile. The investigation now had a genetic identification derived from the original evidence, corroborated by material McCurley had discarded, and corroborated again by a sample he had voluntarily provided. The scientific foundation was complete. On the afternoon of the 21st of September, 2020, the United States Marshals North Texas Fugitive Task Force arrested Glenn Samuel McCurley Jr., then 77 years old, at his home in West Fort Worth. He was charged with capital murder. During a recorded interview with detectives, McCurley initially denied any involvement, stating that he did not recognize Carla Walker. After a period of questioning, he made statements acknowledging responsibility for her death. Investigators noted that his account contained inconsistencies. There were elements of the established timeline and location that he did not describe accurately. This is a detail worth keeping in mind because it becomes relevant later. The strength of the case never rested primarily on his statements. It rested on the science. At a press conference the following day, Carla's brother, Jim Walker, spoke publicly. After naming the exact span of time the family had waited, 46 years, 5 months, and 3 days, he said that, at last, they had a name and a face. The legal proceedings that followed are, in many ways, the most historically significant part of this case, because of what was tested in open court. McCurley was held on a bond of $500,000. His court-appointed defense attorneys entered a plea of not guilty and filed motions to suppress both the DNA evidence and his recorded statements. Their arguments were specific and substantive. They challenged the genealogy laboratory's methods and its accreditation status. They argued that the collection of DNA from his discarded trash, without a warrant, violated the Fourth Amendment protection against unreasonable searches, and they argued that his statements to detectives should not be admitted. These were serious legal questions, and the way the courts resolved them would set important precedents. In May of 2021, the Tarrant County District Attorney's Office announced that it would not seek the death penalty and would instead seek a sentence of life in prison. Carla's family supported that decision. The case was prosecuted by Assistant District Attorney Kim D'Avignon, who led the office's adult sexual assault unit, along with Assistant Chief Emily Dixon. The presiding judge was Elizabeth Beach of Criminal District Court No. 1. Jury selection began on the 19th of August, 2021. Opening statements and testimony began the following day. Over the first 2 days of the trial, the prosecution presented its evidence through a series of witnesses, and this is where the case made history. Rodney McCoy testified about the events in the parking lot. Retired Detective Jim Minter and other retired officers testified about the original 1974 investigation, including the limitations they had worked under. An analyst from the Serological Research Institute, Mallory Pagenkopf, testified about how the single-source genetic profile had been developed from the barely visible stain on the undergarment strap. Witnesses associated with Othram, including a member of its scientific team, testified about the genome sequencing and the genealogical work that produced the surname. Detective Bennett testified about the telephone call on the 4th of July and the steps taken to confirm the identification. Prosecutors also revealed a piece of evidence that had been recovered during the search of McCurley's home. The .22 caliber Ruger, the very firearm he had claimed, in 1974, had been stolen while he was fishing, was found concealed in a compartment above a doorway in his house. The weapon he had told the original detectives was gone had been in his possession the entire time. The prosecution played approximately 3 hours of McCurley's recorded interview for the jury, and they presented the DNA evidence, the profile from the evidence, the match to the discarded straw, the match to the voluntary swab. Then, on the 24th of August, 2021, the third day of the trial, the proceedings took an unexpected turn. Rather than continue, McCurley submitted a written judicial confession, changed his plea to guilty, and waived his right to have the jury decide his fate. Judge Beach addressed him directly, stating that based on his plea of guilty, the judicial confession, and all of the evidence before the court, she found him guilty and sentenced him to life in prison in the Texas Department of Criminal Justice. Carla's siblings delivered victim impact statements. Her brother stood before McCurley and urged him to bring closure to any other families who might be waiting for answers. Prosecutor d'Avignon later reflected that the evidence presented in court up to that point had likely made McCurley realize there was no path to acquittal. Detective Bennett explained the significance plainly. In earlier cases that relied on this method, including the most famous ones, the defendants had entered plea agreements before the science was ever tested in front of a jury. In this case, the evidence was presented in open court, subjected to cross-examination, and the defense's challenges to it were argued in full before McCurley changed his plea. It is a characterization made by the people directly involved, and it is worth presenting as their well-supported claim. Because McCurley entered what is known as an open plea, while reserving his right to appeal the pretrial rulings, the legal questions his attorneys had raised did not disappear. They proceeded to the Second Court of Appeals in Fort Worth, which issued its decision on the 31st of August, 2022, in the case of McCurley v. State. The court affirmed the conviction, and in doing so, addressed each of the defense's arguments in detail. For anyone interested in how the law is adapting to this new forensic method, the ruling is instructive. The defense had argued that the Genealogy Laboratory's evidence should have been excluded because the laboratory was not accredited by the relevant Texas Commission and used analysts who were not licensed under the state statute. The appeals court assumed, without deciding, that there might have been error, but held that any such error was harmless. The reason was that the genealogical lead did not, by itself, convict McCurley. It was corroborated by his own voluntarily provided DNA sample, and it was that independent confirmation that carried the weight. The defense argued that the initial laboratory profile was compromised because an unlicensed employee had performed part of the work. The court rejected this, finding that the employee's role was limited to routine preparatory tasks, essentially loading equipment, rather than the analysis itself, which was performed by a licensed analyst. The defense raised a novel and constitutionally significant argument regarding the trash. They contended that even if discarded garbage can ordinarily be collected without a warrant, the application of advanced DNA sequencing to that garbage was so invasive that it should require a warrant. The court declined to create such a rule. It noted that McCurley had conceded he abandoned the trash and that police had obtained it without any misconduct, meaning he had no standing to contest the search. The court further observed that none of the prior legal precedents the defense cited involved the search of clearly abandoned personal property and that no such warrant requirement existed in Texas or, as far as the court could determine, anywhere else in the nation. The court also held that even setting the trash aside, the DNA from it was entirely cumulative of the voluntary sample McCurley had provided. Finally, the defense argued that McCurley's statements had been improperly induced. The court examined the exchange and found no improper promise had been made. Having overruled all of the arguments raised on appeal, the court affirmed the judgment of the trial court. The ruling matters beyond this single case. It represents one of the early appellate examinations of how forensic genetic genealogy fits within existing constitutional and evidentiary frameworks, and it reinforced a principle that investigators using this method now treat as fundamental. The genealogy provides a lead, and independent confirmation provides the proof. Glenn Samuel McCurley Jr. was incarcerated within the Texas Department of Criminal Justice. In December of 2021, he gave an interview to a journalist in which he recanted his confession. He died in prison on the 15th of July, 2023, at the age of 80. Reporting on the location of his death is not entirely consistent across sources. Local reporting from the Fort Worth Star-Telegram indicated he died of natural causes while serving his sentence at the Telford unit in Bowie County, while some other accounts named a different facility. Let us return finally to where we began, to that interview room in the spring of 1974, and to the decision to cross a name off a list. The detectives who cleared Glenn McCurley that year were not careless. They were working with the tools their era provided. They had a firearm trace, an explanation, and a polygraph result, and by the standards and technology of 1974, they made a defensible judgment. The reason the case remained unsolved for 46 years is not that anyone failed to work it. It is that the evidence needed to solve it, the biological material on that undergarment strap, could not be read by any technology that existed at the time. The answer was physically present in the evidence room for decades. No one on Earth had the means to interpret it. What changed was not the evidence. The evidence never changed. What changed was the science, the development of forensic-grade genome sequencing, the growth of public genealogy databases, and the painstaking work of building family trees from a partial genetic profile. These advances reached back across 46 years and did what generations of detectives could not. They connected a stain on a piece of preserved clothing to a single name. And this is the deeper lesson of the Carla Walker case, the reason it is studied and cited and named in federal legislation. It demonstrates that a cold case is not necessarily an unsolvable case. It may simply be a case waiting for the science to catch up. Across the United States, in evidence rooms and storage facilities, there are countless preserved samples from unsolved cases, sitting quietly, holding answers that no current method can yet extract. The Carla Walker case is proof that patience, preservation, and scientific progress can, in time, give families the names they have waited decades to hear. Carla Walker was 17 years old. Her family waited 46 years, 5 months, and 3 days for an answer. In the end, that answer did not come from a witness or a confession. It came from the careful preservation of evidence, the persistence of 2 cold case detectives, and a forensic method that turned a few billionths of a gram of genetic material into a name that a court of law could accept. That is the case, that is the science, and that is why it matters. Thank you for watching True Crime Files Decoded. If this documentary helped you understand how forensic genetic genealogy actually works and how it is changing the outcome of cases once considered permanently unsolved, please like this video, share your thoughts in the comments, and subscribe so you don't miss the next case in this series. We'll see you in the next investigation.